Okay, so we're continuing here. I'm sorry for that noise. That is when I get an email, it makes a noise like that. I get a lot of emails. Okay, so we're continuing with the four exceptions to prior restraint. These are the times or the situations during which a judge can issue an injunction to a journalist and say, you can't write this. One uh, is if it obstructs military recruitment, and if it's a publication of sailing dates and the number and location of troops. This is especially important because this is definitely has to do with national security. If you give away where our troops are, our enemies hear about that and they can attack us where they are. So journalists today can be in the trenches with soldiers, but they cannot tell anyone, not even family, where they are. And you cannot do anything that obstructs military recruitment. Another situation is obscenity. You cannot print or publish obscenity. And then you cannot publish an incitement to violent overthrow of the government. This even goes to, let's say you're on an airplane and you scream some kind of threat to the government. Trust me, the pilot will land the plane and you'll be taken into custody. You cannot threaten the safety of anyone in the United States. And then four, protection of private rights according to equitable principles. For example, to protect a defendant's right to a fair trial, or to protect a plaintiff's right to intellectual property. That last one, to protect a plaintiff's right to intellectual property, that has to do with the law of equity that I was just referring to before, but didn't say. According to protect a defendant's right to a fair trial. So if you see a celebrity trial going on and the judge is afraid that that person will not get a fair trial, that judge can tell the press that they cannot expose anything that they've learned about the case. They cannot expose a confession. They cannot expose who the jurors are, anything. Very rarely done. It's called a gag rule. So very, very rare. Now on to 17. What are the exceptions to prior restraint? We have another very important case called Nebraska Press Association v. Stewart. The Supreme Court wrote, prior restraints on speech and publication are the most serious and least tolerable infringement on First Amendment rights. This lays it out there, plain as day. I said to you that was the worst term you could think of for a publication, for a journalist, and it's right here. They are the most serious and least tolerable infringement on First Amendment rights. There you have it. Thank you, Supreme Court. So, in this very case, Nebraska Press Association v. Stewart, 1976, here's the story. On October 18, 1975, the police found that 6 members of the Kelly family had been murdered. The crime attracted widespread media coverage, and both the prosecutor and defense attorney sought an order restraining coverage of the murders to deter the potential prejudicial effect on a future jury. They didn't want to dirty the pool of potential jurors. They didn't want to make them feel a certain way, one way or the other, toward the defendant. And they were afraid. This was a very small town. Everybody knew everybody. The Nebraska Supreme Court modified the restraining order and then affirmed it as modified. They did have a restraining order. The petitioner sought review of the Supreme Court of the United States. the Supreme Court reversed, holding that the lower courts needed to determine whether alternative measures in comparison to suppression of the press. Now, look at what they're doing. They're leaning over backwards here to make sure that the defendant is being treated fairly. In comparison to suppression of the press, were feasible considering the circumstances of the case. The Supreme Court found that there was no determination as to whether the alternative measures would have protected the potential defendant, and thus the restraining order was invalid as it was unnecessarily burdensome. In other words, did the attorneys try anything else before they asked for prior restraint? In other words, did they ask to move the trial to a different location, a different venue? Did they try to say that the jury had to stay together and be sequestered and not be able to go out and talk to the public? Did they try that? No, they didn't try anything. They went first to prior restraint, and that's why the Supreme Court came back and said, you didn't try to eliminate the need for prior restraint. Therefore, you don't get it. A good question to have anywhere throughout here is, who constitutes the press? What is the press? And of course, today, rather than looking back in 1976, before the internet, today all kinds of people claim to be the press. I owned a consumer magazine, and so I made myself a press card or press badge, and I went in to watch Michael Jordan, the basketball player, play his first game of baseball. It was a AAA game in Alabama, and we went in and we said, we're the press, and we came in. I hope it's a little stricter these days, that you really have to prove that you're part of the press. But, I mean, I was, but is a blogger part of the press? They don't work for anybody but themselves, and you will find that they are definitely considered part of the press because they've been sued. They have been successfully sued for things that they have written. So, what constitutes the press? The First Amendment says, or abridging the freedom of speech or of the press. What is the press? Well, let's talk about it a little bit. We go back to a case from the 1960s called Tinker v. Des Moines. That's the shortened version. So a sister and a brother, Mary Beth and John Tinker, who were junior high or high school students. And I'm going to go through, like I will in the future with our cases, what are the facts of the case, what issue was the court asked to decide, and what did the court say and why. So let's talk about this. In 1965, 13-year-old Mary Beth Tinker and 15-year-old John Tinker attended an anti-Vietnam War meeting. The attendees decided to publicize their objections to the hostilities in Vietnam by wearing black armbands during the holiday season and by fasting on December 16th and New Year's Eve. This was their protest, folks. Armbands. Black armbands with a peace symbol on them. That was their protest. They went to school wearing the armbands. When the principals of the Des Moines schools, that's Des Moines, Iowa, became aware of the plan to wear armbands, they met and quickly adopted a policy that any student wearing an armband to school would be asked to remove it. And if the student refused, he or she would be suspended until he or she returned without the armband. The Tinkers were aware of the regulation, and meaning that they purposely wore those armbands in protest. On December 16th, the Tinkers wore black armbands to their schools. They were sent home and suspended from school until they would come back without their armbands. They did not return to school until after the planned period for wearing the armbands had expired, that is, until after New Year's Day. Slide 24. So what are the results? What happened? Were they punished? What was the outcome? Students, the statement, the decision stated that students do not surrender their constitutional rights simply by entering a public school. The prohibition of expression of one particular opinion is not constitutionally permissible, and a student has the right to express his or her opinions even on controversial subjects. In other words, this was expressive. This is what we call symbolic communication. It was an armband. The armband meant something with the peace symbol on it. It meant that they were against the Vietnam War. They didn't say anything. They didn't yell. They didn't hold up posters. They just wore the armband. And the Supreme Court said they have the right to do this. The school has the burden of showing that the student's speech materially and substantially interfered with the requirements of appropriate discipline in the operation of the school and without colliding with the rights of others. One of the basic rights that teachers have is that they can teach without being prevented from teaching. Nobody can materially interfere with their job, which is teaching.